So another common question that I get asked quite a bit about is clients will come in and say, well, it's just a group of us, family and friends, putting our money together to invest in some kind of a deal. It's not really a securities offering. It's a joint venture or a partnership. So I'm going to discuss a little bit about what makes a difference between the two. I'm going to share my screen here. So what is a securities offering or just a joint venture or partnership? So the first question is, what exactly is a security? So this is the definition that's in the Securities Act. It's a pretty long definition, but it covers just about anything and everything under the sun, and that's the way the SEC has interpreted it. So that can be common stock, preferred stock, membership interests in an LLC, units, Class A units, Class B units, promissory notes, loans, profit sharing plans, just about anything you can think of. And I've also highlighted the term investment contract in here because that's one of the common areas that the SEC looks at to determine if something is or is not a security. They do an investment contract analysis. And what's a security offering? Basically, when you go out and try to raise capital. So you're trying to bring investors in and you're essentially offering to sell them a security. You put $100,000 in and you'll get 10,000 Class A units of my LLC. And that's a security offering. Now, the investment contract analysis is usually basically referred to as the Howey test, which is a case from a while back, where the SEC defined what is an investment contract, therefore clarifying that this is a security. So this is usually what's looked at to determine if something is or is not a security. So an ownership interest in the LLC may or may not be a security, depending on the Howey test. So it's essentially the investment of money in a common enterprise with an expectation of profits. So here it's just a traditional investment up until this point, derived from the efforts of others. So basically, you're a passive investor. You're putting your money into something, expecting a profit or a return, but you're not the one putting in the work to make that return happen. So when you look at what people call a JV, joint venture, or partnership, usually it might be something similar where a group of people come together, pool their money to put into some type of an investment or buy a real estate, whatever it is, and they consider it a partnership or a joint venture. They do a quick agreement and they think that's fine, and it's not. It doesn't matter if you call it a JV or you call it a partnership or you're all friends. It's a different analysis on whether it is or is not a security. So we have to look at the Howey test. And the most common area to look at is the fourth factor about, is it based upon the efforts of others? If you're a passive investor, then it's typically going to be viewed as a security, and the investment is a securities offering covered by securities law, meaning you need an exemption, 506B, 506C, Reg D, Reg A. There's a number of exemptions that you need to find for that securities offering, or you violated securities law on probably a federal and state level. So it's important that you understand that you have to clarify this and understand whether it's a security or not, because that's going to impact how you deal with it. Just because you call it a joint venture doesn't mean it is. And, you could be in a position where you didn't have an exemption and you have to return your money to your investors, and maybe it's already spent. So it's got to come out of your own pocket personally. So there are some implications, and that's beyond any kind of regulatory criminal issues that could come up depending on exactly what happened in the investment. So it is important. And, clients come in all the time and say, well, it's just a group of us, that put our money together and invested in real estate. And so it's just a JV, and here's our LLC agreement, operating agreement, or maybe we even have none. But basically you find out that it's 30 or 40 investors put money in, and most of them have no say in how anything is managed. And it's managed by 2 or 3 guys that are the managers or in control of it. And the investors are pretty much passive or have very little voting rights. And so basically, yeah, that's a security. It's a securities offering. It should have been done under an exemption, probably a 506B, which is the most common for your typical family and friends type of offering. But you do have to comply. And if you had unaccredited investors, you needed to provide an offering memorandum, which is a PPM or private placement memorandum, to your investors prior to them putting their money in. You also have filing requirements with the SEC and each state where your investors are located. So it's very important that you understand the difference and you properly classify what you're doing as either a securities offering or it is really just a partnership. And a joint venture, a joint venture is really essentially a partnership. It's just a different legal term. And I won't get into the nuances between it, but basically it's when a group of people come together for a common goal and each puts in something, money, services, whatever it is. But that's just the basics of the difference. And typically, at least from the SEC standpoint, is it a security? Probably 99% of the time they're going to say yes, it was a security, including recently with crypto, coin offerings, NFTs. Those are all going the way of considering all of that securities that need to be regulated.